Too often in the case.
Yeah. What do you want me to do?
Oh,
I'll help correct it.
I
Thanks.
just ran stuff with something.
T overrule equals holding. A definitions. 1. Overrule means to avoid the holding of a prior case. Alice Legal Service 2000. The overrule means to avoid the holding of a prior case. And 2. The holding of more similar set of federal civil remedy to gender-motivated violence is unconstitutional. Topical acts must defend VAWA. Being topical means they must defend civil remedies. SCOTUS 2000. Held. Section 13981 cannot be sustained in the Commerce Clause of the 14th Amendment. Clause does not provide Congress with the authority to enact 13981 follows civil or federal civil remedy. Congressional act can be validated upon plaintiff when the Congress exceeds constitutional bounds. Proper framework and analysis of claims whatever the principles of court set and love gender-motivated crimes, violence, or not in any sense economic activity. And violation. The act overrules rationale for the holding, not the holding itself, because gender is economic without taking the second step of saying that this means that VAWA is constitutional. This is Abramowitz and Stearns 2005. Consider the ancient distinction between the holding and the ratio to consider the case. The actual holding must be stated when narrowly encompassing precise pointed issue. In the case that the ratio provides the general applicable rule of law. The opinion is held holding the rest. The ratio must be distinguished from the rule of law case, being the principle which case stands the principle made to be the law and subsequent case law. And standards, limits. Under the absent interpretation case can overturn any word or phrase made in the multiple page to the majority opinion. Under our interpretation, the affirmative held the ruling whether or not VAWA is constitutional with the substantial effects test. And predictability. Negatives have no way to predict all the ways that gender could be considered economic or not. However, we can easily research the effects of VAWA in the two-paragraph holding. And ground. VAWA is essential for negative ground for more instances on what the decision was actually about, making the debate solely about whether or not gender is economic. Also, this discussion of substantial effects test, which is a critical part of the holding. And extra topicality, moving gender-motivated violence to the center of power is part of the rationale and doesn't overturn the decision. It's extra topical and is vote for fairness. At least reject the extra topical portion, meaning they have no solvency. And topicality is a vote for fairness, education, and competitive equity. And the critique. 1. Locating the sphere of power in any one area is bad. Their plain text says something with gender-motivated violence to the center of power. This myth that the center of power is precisely what Foucault teaches is bad. It's an oversimplification, and it reifies oppression. This is Bovin 88. Power effects need to be diagrammed because they're not going to be raising any concept that thought that sets up the expansive equivalent notion that the capital state can be opposed to a work position, not set itself as an advocate guide to oppositions, and since upon describing itself a repulsion is what it hopes to negate. It's an inadequate reflection of the dispersed effects of power within the capitalist society. The notion is future proposition for its even civil dialectic of the moment of critical blindness. It results and also develops in unwillingness to consider relations of oppositional practice, the institutionalized forms of discourse, which the dominant forms of power and knowledge sometimes have constituted effects. One can identify power and look at it as unlikely to be specific ones and inscription power and knowledge apparatus. And this state-centric model of power makes the oppression inevitable as Foucault in 80. To be able to face it with more than just governing the revolutionary movement possesses equivalent political military force and his was constituted itself as part of the classical non-garden and without establishment of dictatorship of proletariat in order to operate these state apparatuses which take over the state of nation specialists has happened in the USSR when commissions for avoiding repetition of the Soviet experience. First things has to be understood that power is localized to the state apparatus. And the Supreme Court, their app is premised on the assumptions that the Supreme Court is the center of power. Now, this assumption perpetuates a negative relation to life that makes life not worth living. This is Cardi in 2003. Law restraints the exercise of power is the majority which is restraining power, but an ethic responsibility of an interest of the player, the stronger free to be weak and the person anyone is not retaliate. This type of man needs to believe in unbiased subject with freedom of choice. This is dismissal of the very foundation of the rule of law and basic rights, a vision of transcendent by the empirical bustle of everyday politics and fantasy feeling to entire other worldly non-existent spaces only draw those who yearn out away from effective battling with worldly cats of actual incredible planetary antithesis, a fearless door life denying cowardice, the language just and not merely her resentment. This is self-destructive death wish and failure to accept limitations being which pursues consistently successfully can mean total self-annihilation, the ineffable justice and reality resignation facing the intangibility of stern liberalism, contracting foundation of legitimacy, the just and unjust system in the topic of legal system, state of legality can be anything but exceptional changes in partial restriction, the true will of life system laws conceive the time that every will to regard free of the will as equal and be principle hostile life and attempt to assess in the future meaning the deconceived path of nothingness. And when morality is qualified as universal, the law of republic is the republic of the guillotine, as its anger at humanity's inability to live up to the law's perfections results in excessive state resentment, which manifests itself in the form of state terror. This is changed in 2003. A society of absolute justice necessarily harbors terror within itself. Absolute virtue is possible in the republic of fitness and political logic is the republic of the guillotine. Absolute virtue is kept from me by absolute and flexible law. That's no state of human being can measure up every that is regarding coming from imperfection in law, which is presumed to be impossible from lack of virtue in the factory citizen. The imperfection of the big government can see by transferring whenever conflicts arise. Morality when it's formed of powers, morality alone does not need terror. Something morality serves itself as absolutely inflexible to become sadistic. Absolute virtue can exist only as a form of rational idea unresponsive to empirical and human reality to reaffirm its absolute truth and most reason even eliminate reality. Full sovereignty remains unchallenged. Revolutionary temptation implement the version of new society and to demonstrate the difference between standing between the bad and the revolutionary eager to form not only society but also humanity. Revolution did have something set of principle and virtues of state imposed ability and politics of slavery rather than master name of slavery looks to which again entire states to the second level of slavery until the understanding subordinates its subjects to an opaque bondage to ideological claims to reduction in means slavishness and total dependence on the regime would constitute crimes. When a revolutionary government becomes demoralized by its failure to form the world according to values, ready to take their mainstream regime with the deficient understanding world tends to impose its ideal order in the world and said that's found to run an obstacle due to the evidence of the world tries to perform this moment the regime finds enemy has become its enemy once submits the way the regime regards itself with an exaggerated degree of self-righteousness. The regime starts to no prowess and turn resentment which unleashes anxiety and form terror and the failure of the regime experiences version of its fallen attempt the regime to perform to the world ends up being a reforming itself with its good intentions perpetually inverted perverted thing himself the absolute crime originating the side of absolute virtue and utopia on the other side of utopia. And the alternative, we must reject universal moralities of equality in favor of formative moralities and only in character-oriented ethics, self-negative values, life. This is program 2003. Nietzsche's product analysis for the reevaluation of values. Nietzsche does alternative affirmative morality, but differs from nature of morality, being a different action step in second person. The fundamental aspect is the emphasis of personality and character speaking to God due to the fact that God does not exist because believing God makes man smaller. 3. And ethical tradition comes standard the ethic of virtue, utilitarian ethic, theological ethics as virtuous character-oriented, while the other two forms are act-oriented. Modern ethics is probably oriented which way is correct act in these circumstances. Virtues responds to a very different question. There shall balance of life, which sort of person should I become? All philosophers are concerned with what is to be done with questions where faced to is to be created in action is perfectly devoid of all value depends on human performance and ideas, principles, justify actions, and improvements, but human beings who either may or may not ensure both justify and improve man because they're examples of what man can be. And case. 1. Status quo solves. A. VAWA 2. Passed and it's constitutional. House Term 2002. On 2001, Congress enacted VAWA Civil Rights Restoration Act. This authorized the Attorney General to file suits reasonable, showing that the state political subdivision or state agent discriminated based on general investigation, prosecution, and general crime because it's targeted state act specifically like beside the Supreme Court scrutiny, and B. Garnish movements necessary to solve case. Davis 2001. I think it's organized and rebuilding groundwork linked to VAWA legislative and stand 6 knowledge that cannot go it alone. It will help women. Law would also permit the Attorney General to take action to new provision and non-prior laws. This operative process will handle long-term campaigning private violence and appropriate based on national public policy will last more and we will win the campaign against violence against women. And 5. Symbolism term. A. Civil remedy is purely symbolic. It doesn't do anything. Reagan 99. The civil rights remedy resides in the category of provable law against bad weather abuse from electing the civil rights action against your partner in federal courts and no position taken upon the socialism and retreat in the face of highly publicized symbolic actions. TR is very cheap. Very, very cheap. Fictitious plaintiffs the lawsuits started imaginary twins fail judgment legal bill and civil rights remedy America get exactly what it paid for. And B. Symbolization guarantees rollback of women's rights as a Rosenberg 2006. Litigation simply symbol for acceptance class the purchase movement of a rose birth infiltration growing resegregation in the frame time when ground is geomethical symbolic sense and they're celebrating symbolically since 2015 since today ground is little more than normal that political support coordination on futures for change of value rights courts agreed for performance of the political support is lacking effect on change by defending claims for reform over substantive battles or says possible harmless legal ones were not correlate deeply conservative ideological in defense of the status quo. And civil suits commodify justice, makeshift our first priority away from money to solve. This has been there in 90. Money is inadequate to solve the pain loss of victims. Money is proven inadequate to harm saving penalty need for a mentioned approach we are so inculcated with dominating ideological practices of vision and something is never avoid social, economic, political, citizen situation. You try to solve the problem by earning money. We did even the same thing. We need to prioritize rather than value dollars, and we need to develop remedies as the money damages. And 6. Victimization turn. A. Civil remedy forces women to portray themselves as victims in court in order to win. This is Carr in 2003. Legal interpretations leave women in double bind the burden of rationally proving that the matter of relations which sufficiently life earning is placed on the truth by asking when they never attempt to leave and if they go to the archetypal program. But if you're a victim or by being angry, then they are judged on truly victims, therefore not merely legal adjust. All inflated by definition from the structure the heart of the issue, living circumstances, dichotomies, it's separating the autonomism, the victimized by standards of liability, refile the altered from the stereotypes, unless the victims turn overwhelming evidence protests against abuse, and unless they're thoroughly consensual and then one legitimate. In the legal redress plaintiff has proved that she had become clearly an agentless victim rather than a partial victim and partial agent. And B. This victimization reinforces patriarchy. This is Picard, 2003. VAWA aimed at liberating women from system and imagery of violence, rallying by the female victim, is intentionally stabilizing the battle cry versus women's weakness, which have a patriarchal point of view, and what makes women step through a place of virtue, provides even the fatal error, strengthening patriarchal constitution of sex and gender as inevitabilities. And 1:30.
You just go.
I'm going to read this. Alright. TX.
Okay. So, the critique. First, read these two cards that say that state power is bad. How do we link these?
It's not that state power is bad, but your assumption that the state is the center of power is bad.
That the state is the center of power?
Which is a quote from...
Specifically, your plain text that we overruled the decision by moving gender-motivated violence to the center of power.
There is no such thing as a
There is no center of power.
The assumption of there being centers necessarily makes non-centers, which the evidence says causes repression.
And additionally, when you place the Supreme Court as the center of power, it's a negative relation to life.
Where do you see that?
That's
Oh, okay.
the bold underlined part.
Right.
Wait, no, like what part of your evidence is talking about? I mean, it says when you say that one thing is the cause of all something. I mean,
That's not really what our evidence says. Our evidence is just the code and power relations card that says power is everywhere. Your assumption and your decision to say the Supreme Court's decision is the center of power and models and determines everyone else's lives and how they
Or
live.
that we can grab the power from the Supreme Court specifically is when you talk about the 9 justices. It's not in the hands of the 9 justices or whatever.
Sure,
we have the
so
power and the Supreme Court's the center of power.
Okay, so by...
And we can take that power back.
You misrepresent power, and your misrepresentation is bad because it is responsible for the very types
Right,
of...
but can't you say that there's
refusal
more
violence as well.
control in one area or more power in one area than another?
No.
It's equal everywhere?
Power is everywhere. And it's
Yeah. Power is not like gun
Well,
slash.
sure.
It's much more.
I know that.
And our cards
right,
are
it flows through
specific to
society.
your-
So you can't say.
And our cards are specific of your assignment of this massive power to the state. Not just in general, an assignment of power.
Okay. All right. So then the Nietzsche stuff says that is this party evidence is saying that basing the evaluations of ourselves on what the Supreme Court says is bad?
Yeah, I mean, when we look at the Supreme Court. And we need to steal the power from the Supreme Court rather than with
You
ourselves.
shouldn't care about the Supreme Court power.
It shouldn't ever enter into our decision-making process.
Right. But okay. What about the fact when we say that it's the people that matter, that it's the violence happens on an individual level, that the power of the Supreme Court's in the hands of the people? Where do we say
Right,
that?
when
We're
you say
like-
the power of the Supreme Court's in the hands of the people, that's the problem.
Why?
Because the Supreme Court doesn't have any power that we don't already have, and relying on it.
We can agree with everything
Right.
the affirmative is, except for
Except-
I don't
characterization
understand.
of why are apps different than the status quo or what.
Right. Okay.
status quo.
I don't understand your thesis here. Is it that we put too much power in the Supreme Court, or is that we say that
You
there's
say
no
there are
power in the
centers of
Supreme
power.
We
Court?
say there
Court
are
from
centers of
160.
power, and the Supreme Court is one of them, and we need to take that power back from the Supreme Court.
That is a bad model of power, which we say you do, and we don't do. We still
We
allow
have an
presentations
alternative.
of body.
Right. Okay. Explain your alternatives.
Our alternative is virtue ethics, which
What does that
basically,
mean?
rather, alright, so virtue ethics basically, instead of relying upon utilitarian calculus or some sort of deontological framework, means that we should judge values based on character assumptions that don't rely on the Supreme Court. We shouldn't look at the Supreme Court, we should just say, sexism is a character stain, that's bad, that's not a virtue to have. Therefore, I'll reject it.
Okay. It says here that you determine it. This asks the question: how should one live one's life, and what sort of person should I be and become? How do we exclude that? People asking,
Because-
how should I live my life, when we say that like violence happens.
We
on
say
an
the judge,
individual
rather
level.
than asking, how should I get the power from the Supreme Court, should say, how can I go about rejecting sexism myself?
It doesn't have to overrule the Supreme Court decision in order to say that
Sexism is
women are
bad.
generated violence is a loci of power.
Okay, so are you solving for the case with the alternative?
Yes.
Really, Nietzsche would agree with. the
We're
idea that-
not traditional Nietzschean ethics. That's our alternative card. We are not like Big Lebowski.
Nietzsche
Everything that's good
would
is
much
bad.
prefer us rejecting it as a character stain than looking to the Supreme Court as a source of power.
Right.
Yes, he would.